Have you ever had to turn down a candidate for hire or terminate an employee because of their criminal history? Maybe you learned they were a registered sex offender or committed grand theft auto. Maybe you already know that in many states, you are not allowed to even inquire about criminal history until after a contingent job offer has been made. Maybe you have a checklist that you follow to confirm you can legally take adverse action based on things like nature of crime, recency, and relationship to the job, so that you aren't applying a blanket policy regarding convictions. Maybe you even know that the Fair Credit Reporting Act, yep, the same FCRA that covers consumer credit reports, also places requirements on employers regarding criminal background checks. Did you also know that the same law requires employers to send a pre-adverse action notice prior to finalizing any decision not to hire, not to promote, to terminate? And that same law requires another notice be sent called a post-adverse action notice to signify that the decision is final. Now, this does not mean that you can't take action you deem appropriate given the nature of the conviction. You may elect to suspend the individual pending this process, and it doesn't mean that you have to hire that person or retain someone who may reasonably be a threat to your company. It just means that there are some additional rules to follow prior to making these decisions. This topic has been highly litigated in recent years, and some states have even more stringent rules than the FCRA when it comes to taking adverse action against felons. So our advice, as usual, is to work with an HR pro or employment law attorney before making these moves.